Hello and welcome to the Herrington Carmichael Employment Law Update for January 2017. Happy New Year! My name's Alistair MacArthur, I'm the Head of Employment with Herrington Carmichael, and as always each month I've got 4 key employment law updates for you. So where to begin? Gender pay gap reporting. In the last month we've seen the latest set of regulations published. These regulations clarify a number of concerns that employers had around what data they were going to have to publish. Now, as you may remember, these regulations require employers of more than 250 employees to publish data on pay and on bonuses. What we've had is some clarification around these regulations in terms of the reporting requirements and employees who are and who are not going to fall in those reporting requirements. So in particular, employees on maternity and sick leave potentially fall outside of the requirements. We're still waiting for the government guidance to come through on this, and when it is published we'll be providing more information for you, so watch out for that. If you do have more than 250 employees and you're watching this blog though, I'd highly recommend you start looking at this issue, and please do get in touch with us on the contact details provided. Next, reform of the Employment Tribunal Service. The Employment Tribunal Service for a long time has been criticised about being cumbersome and out of date. However, we've now got a couple of consultations taking place about updating that, and in particular digitising the whole claim process to make it easier for claimants. Watch this space. Let's see what happens. It's only at the consultation stage and I'd expect a lot more to come on this. Next, the case of Herrington and Dudley deals with the issue of whether stress can amount to a disability within the terms of the Equality Act. Within this decision, the Tribunal said that stress alone could not be a disability. It had to have something more. A pure reaction to life events was not sufficient to fall within the requirements of the Equality Act. If you have stress, you'd need to also be arguing that you have anxiety and depression for your conditions to qualify as a disability. But each case has to be determined on its own facts, and again we highly recommend that you take legal advice. Finally, the case of Bellman and Northampton Recruitment. This is a continuation and a change in the line of cases around the Morrison's type decisions in relation to assault or liability for assaults within employment. In this case we have a Christmas party at the golf club, which is all fine, don't worry. It then carries on into a hotel, and unfortunately an incident occurs between a managing director and a senior employee which results in harm being caused to that senior employee, and some quite considerable harm in fact. That employee pursued a personal injury claim, and it was found that the employer was not liable in these circumstances because it was found that the party at the hotel was not part of work events. Each of these cases has again to be considered its own facts, and therefore we still recommend to employers that they have very clear policies and training about what is appropriate in the workplace. That's it from me this month. I'd like to thank you for your time, and I'll be back in February. Thank you.